a new office in Louisiana. So if any of you dabble down Louisiana, we do have an office there that is run by Lucas Moorhead and Steve Mullins. Also, as Bill stated, a blog's a big part of Merlin Law Group. We update it every day. Just a few interesting blogs recently within the last week. One, Shane Smith filed an amicus brief up in Connecticut. There was a big Supreme Court decision up in Connecticut in terms of matching and appraisals. Matching can be considered an appraisals up in Connecticut. Also, there's a case down in Florida, UPC. There's a lawsuit filed against UPC. There's apparently text evidence and also testimony from field adjusters from UPC that are getting told by desk adjusters to deny what would otherwise be covered losses. So that's very interesting. Also, one other one, Sean Marker, another attorney in our firm, unfortunately had a fire at his residence. Very interesting blog in terms of how he's dealt with that and what he went through. So yeah, if you don't, you could subscribe to our blog. You reach out, email me, and we'll get you lined up to get a subscription for it as well. So I'm here today. I'm going to be presenting. It's a presentation called Case Studies in Pennsylvania Residency and Sudden and Accidental Loss in New Jersey. So basically, it's a case study. It's two cases that I've handled, one in the Western District of Pennsylvania and one in Burlington County, New Jersey. They'll go over those two issues. Before I jump right into it, there's my mugshot, my contact information. I run the Red Bank office in New Jersey. My cell phone is up there, 610-442-5198. For those of you that work with me, you know, I'll answer your calls. And if I don't, I'll shoot you a text right away as to why I can't answer your call. Also, as Bill alluded to, I am in the process of getting licensed in Ohio. I do currently have a Pro Hoc Vice license I renew every year, but this year I should finalize my application. Just waiting on the certificate of good standings. And once that's done, I should be good around probably midpoint this year. I'm doing the same in Connecticut and New York and getting all three out of the way at the same time. So hopefully after this next coming year, I'll be licensed in Connecticut, New York, Ohio. I'm already licensed in Pennsylvania, New Jersey, and also Florida. I also have local counsel throughout the Northeast. Since joining Merlin, I've handled cases in 11 different states. So I don't have to be licensed in that particular state to handle cases. I do have local counsel. So really the far stretch of the Northeast, anywhere, feel free to give us a call. All right, so jumping into it, I do know this is wild card weekend and we do have a full slate of games at 4:15. So let's get to it. Pennsylvania residency overview. I will get into basically how, now I'll let you know, throughout the country, in terms of the residency issue, it's essentially split 50-50. And my toddler's entering the room now. So case study, the case study will be on the Western District of Pennsylvania case I handled this year in terms of the residency issue. It involved an older gentleman who went out and moved out because he was moving into a retirement castle, rented out to a neighbor next door, and unfortunately there was a fire and a complete loss at the structure. Insurance company is relying on, they're trying to exclude it based off residency. We'll then move into the case regarding sudden and accidental in New Jersey. We'll get into whether or not sudden and accidental is defined in insurance policies, and if not, what happens, what judges do when certain terms of the policy are not defined within that policy. And we'll get into the case study, which revolved around a hidden failed wax ring on a second floor bathroom, which caused damage throughout the property. Before I get into this, I know public adjusters don't need to know this, but both cases revolve around what's called a motion for summary judgment. These are motions that attorneys file after the close of, usually after the close of discovery. Once all the depositions are done, once written discovery is done, once expert reports are put in, and there's no further discovery coming in, either plaintiff's counsel or defense counsel can file a motion for summary judgment, which essentially takes the case away from a jury. The attorney is essentially arguing, Judge, we have all the evidence, there's no genuine issue of material fact, and no reasonable jury can come to the conclusion that we don't win. We should win on the papers. Judge, you should intercept the jury, and we should win based on my well-written brief, and they have nothing to back up their argument in this case. And both cases I'll discuss today involve those motions. Um, there are risks. It's just very strategic. Either side doesn't have to file a motion for summary judgment. Like a discovery end date could happen. You could get a trial date, and you could just start preparing for a trial. And typically, as you know, and if you don't know, a lot of these first party homeowners insurance cases end up settling. They very rarely go to trial. There was a study done on this. I believe that it's a very low, minuscule percentage of these cases actually end up trying. Somewhere down the road along the lines of litigation, the case settles. So what the risk of doing this is, there's a few of them. One, you could create bad case law, because at the end, the judge is going to give an order at some point, whether you're right and wrong. It could be a very general order for the attorney saying, okay, well, your motion's accepted or your motion was denied. Or the judge could give a written opinion stating all the facts in terms of why the attorneys were right or wrong. If you're on the wrong side of that equation, well, you're in the case law. You can look it up on Westlaw, and other attorneys can use that order for that same issue down the line, show a judge, okay, well, this has been decided before, and this is how a judge ruled. So an attorney like myself, if I'm filing a motion for summary judgment, I need to be real sure that the judge is going to win, because I don't want the court creating bad case law that could potentially maybe give an insurance company an easier time getting an exclusion passed through the legal system. And it goes up the ladder. Obviously, there's trial courts, which only affects the trial courts. But if you get up to the appellate division, it covers the appellate court. If you get up to the Supreme Court, it covers the state. So there's levels to that as well. And you also, another thing an attorney has to consider is the time. Now, in state court, summary judgments are ruled on relatively quickly, 30 days. So usually around 30 days, but sometimes there's an adjournment for 2 weeks. So within a month or 2 months, you're probably going to get a decision in the state courts. Federal courts, however, is something completely different. Federal courts, if an attorney like me wants to file a motion for summary judgment, I have to let the client know that it's going to take a while. If I think I'm right on this, I'm going to be risking a lot of time on this case, a lot of downtime for this judge to make the determination, because I've had motion for summary judgment in federal courts take 8 months to decide. So I need to let the client know, if I'm doing this, if they're okay with the case sitting for 8 months until a judge makes a determination on my motion. And the last thing to consider is, again, it's not necessary. You don't an attorney like me doesn't have to file the motion. But if I do, it could potentially wake up the other side to file their own cross motion. And specifically as to the New Jersey case today that I'm going to be speaking about, that's exactly what happened. I filed my motion. I get a call from the other side. They weren't going to file a motion, but it woke them up to file a cross motion. And now we're at a point where, instead of probably going down the route of going to a trial and right before trial settling the case, now I've created a situation where if I'm wrong and they're right, they can win coverage and we could get a big fat goose egg. So there's a lot of risk to an attorney like me when I make a decision to file a summary judgment. So again, but there's also pros. It saves the cost of trial. It's potentially spurs settlement discussions. I've used motions for summary judgments on bad faith cases to scare the insurance company into settling, because they fear that potentially you can win on the bad faith motion. And also the potential pro, if you win, you create good case law and the attorney is the hero. So there's pros, cons. There's a lot of strategic issues in terms of an attorney filing a motion for summary judgment. Just wanted to give that background. It's not something public adjusters need to know, but it's fun to know. So getting into the first issue, Pennsylvania residency. Now, I had in the beginning, I had stated whether or not it's favorable or unfavorable. Residency requirement in insurance policies. Now, I'll let you know, the insurance companies, when they're making a residency argument, the area in their policy that they're going to rely on is the residence premises definition in the policy. That's what they point to. So I've used the example, if you could see on the PowerPoint, just one I took from a Middle District of Pennsylvania case. Dwelling means a 1, 2, 3, or 4 family building structure identified as the insured property on the policy declarations where you reside and which is principally used as a private residence. This is just an example. This is not standard language. This language differs between certain policies, but most will include that three-part phrase, where you reside. So getting into situations of non-residency, it happens a lot. And you can expect scenarios where you have an insured who has these situations that potentially examination is going to come, looking with the insurance carrier, trying to build up a case that the insured was not a resident at the property for a certain period of time. So some of these situations I have up on the screen: death of an insured, trust, seller remains after closing, seller moves out after closing. Big one is renovation, homes under construction, vacancy. For the case that I have, nursing homes, you have insureds that are transitioning over to a nursing home. Divorce is another big one. These are just like some examples where you potentially may run into an insurance carrier who's going to try to deny the claim based off of a residency argument. So what factors are considered? So an adjuster coming out on the insurance end who is potentially thinking about using a residency argument, they're going to look at whether the house is furnished. Obviously, if somebody's not living there, the house isn't going to be furnished. I have a PNC who I have to have a serious discussion about because she's saying she was a resident at the property. There's no pictures on the wall. There's no beds made. So I got to find out whether or not she was actually residing at the property, and I have to also read the policy. It's both a fact and a legal argument when you have these cases. Empty refrigerators, they're a telltale sign. Utility bills. If there's an issue, if obviously an insurance requests utility bills and they just kind of flatline, especially in terms of energy, that's an issue. Upkeep of property is the lawn mowed. If you have knee-high grass, either the insured's very lazy or they haven't been residing there. Probably the biggest question, examination under oath in terms of residency: what have they been sleeping at the property? Have they been staying over? How often have they been staying over? Is it weekly, daily? That's going to be a big topic of conversation and examination under oath. Is mail received at the residence? Is the address used for tax purposes? Who has keys to the property? One thing I like to, when I prep for examination under oath, and if you have a client who has an examination under oath, they really need to be represented, because that examination under oath, even though you're not in litigation yet, the transcript from that examination under oath could still be used in arbitration, trial proceeding. So what's testified in examination under oath could have long-lasting impacts during litigation. So it's very, I know this is a pitch, but clients need attorneys for examinations under oath. So when I have an examination under oath or residency issue, I like to make sure that the insured is addressing the residence as my house. It's their house. They don't say that person's house, it's my house. It was a big part of the Middle District of Pennsylvania case called Bloxham v. Allstate, where the insured was able to survive a motion for summary judgment. The last thing is, this is an exhaustive list, but the last to look at, address on driver's license. They'll see if you still have that residency address on the driver's license. Now, I forget when, but Merlin Law Group, we had a great blog in terms of residency. I think it was over the course of this past year, and it cited to an article from Bill Wilson. If you don't know Bill wrote the book When Words Collide. It's a great read if you had a chance to look at it. But he cites some arguments for the insured as to why residency is not so much a requirement of the policy, it shouldn't be excluded. First is the phrase "where you reside" is really more words of description in terms of the resident premises as to describe the property, and not so much a warrant of continuing occupancy that an insurer can read as a condition that requires continued occupancy. Kind of that ties along to it, the "where you reside" language is not clear and conspicuous. It's not an exclusion under the policy that potentially you could say, like a flood exclusion is potentially clear and conspicuous. Here, there is no exclusion in terms of residency. When there's a residency argument, they're pointing to that residence premises definition and expecting an insured reading that resident premises provision, specifically where you reside, to tip them off that they can lose coverage, and there's a condition of continuous occupancy under the policy. And if you don't continue that occupancy, that you're going to lose entire coverage for your policy. And that's a stretch when you really think about it. An insured reading that is not going to be tipped off. It's not an exclusion. Any objective juror, I would think, again, jurors don't make the decision, it's judges. It's a much harder sell for an insurance company instead of pointing to potentially a clear and conspicuous exclusion. Insureds have a reasonable expectation of coverage given the limited exclusions that apply to coverage A and the implications of other policy provisions. Any perceived increase in risk of loss is immaterial or inconsequential compared to the potential of catastrophic loss. To tie in the Western District of Pennsylvania case I have an insured who's lived at that property for 28 years, never made a claim, transitioning over to a nursing home. House burns down actually a day or two after it's being rented, after he evicts it to the tenants, and he loses everything. Insurance company says, well, you didn't continually reside there. It's excluded. Good luck picking up the pieces to your home. When there's not continued occupancy, like say, I could see the insurance company making an argument, okay, when there's not continued occupancy and you leave the property vacant, sure, there's an increased risk for pipes bursting if you're not maintaining heat, or rodents getting in the house and the property is not protected, those kind of issues. But when you're renting out, when an insured like the one I have rents out the property to tenants, those concerns aren't really an issue. The only increased risk now, because he's renting out while he's transitioning to a nursing home and while he's trying to decide if he's eventually going to sell the property after the year the rent's up, is that he's got additional tenants or different tenants of the property. It's really not an increased risk to the insurance company as much as it is for my client should a fire happen to the property and he loses basically everything. It is onerous, unconscionable, and against public policy to exclude all losses to dwelling on the basis that there is a minor increase in risk for some perils. And that essentially ties back to what we just essentially said. My insured in that Pittsburgh case, it's just a very minute increase in risk, if any, by my client renting out the property while it transitions into a nursing home. So in the beginning, I had stated whether or not that basically throughout the country, the states are split, whether they favor or unfavorable in terms of the residency provision and how the courts rule on it. In Pennsylvania, it's generally unfavorable. There's plenty of precedent that favors insurance companies in these type of argument. I've listed 3 cases from the federal courts throughout the Third Circuit. So we have Eastern District of Pennsylvania, Middle District of Pennsylvania, Western District of Pennsylvania. The first one is very damning. Campbell v. State Farm, Eastern District of Pennsylvania case from 2018, stated keeping up with insurance premiums, tending to the lawn, periodic visits, keeping several items of furniture on the premises, so we're going through that checklist, and intent to return to the property is still not enough to establish residence when undisputed that insured had not lived there for 2 years. Now, keep in mind that there's factual considerations, but there's also legal considerations. There's also the residence premises definition, how that ties into that. Now, I'll show you what the Campbell residence premises definition is in a few slides. Bell v. Allstate, Eastern District of Pennsylvania, 2005. When definition of dwelling clearly and unambiguously requires that the property be owner occupied at the time of the loss, insured loses coverage upon moving to a second location. That is very strict coverage language because if you read that, it makes it seem like if you're not residing there at the time of the loss, even if you're away for a day, 2, a week, that could be read that the policy is going to be excluded because lack of residency. However, I do agree that if a resident dwelling provision clearly and ambiguously requires that the property owner be occupied, obviously the more clear and conspicuous, the more it's going to favor the insurance company. So Bell v. Allstate, potentially they may have gotten it right there. Gurrow v. State Auto, Western District of Pennsylvania, 2018. Insured temporarily moving to Connecticut to take care of sick mother. Sporadic visits are simply not enough to create a genuine issue of material fact. And again, you have to tie the facts into the actual policy provisions, what I'll get to. So we'll move into the case study. I've alluded to the facts already. Elderly man, he lived at the property, purchased it with his wife in 1990. Wife dies in 2016. Older man. In January 2019, he falls under ill health, decides he wants to move into a nursing home retirement castle. And the neighbor next door has a son who's in the 20s, and he decides to rent out to the neighbor and his fiance and 2 kids. For a year, he hasn't decided if he's going to sell the property or not, or potentially give a rent to own agreement to the neighbor. There was no documents produced either way. He leaves a furnished house, so he's leaving personal property in there, which is also an issue in the motion. Lease expires, and plaintiff evicts the tenants. A fire occurs as the tenants are moving out, burns the house down, total loss. So those are the facts that we have. Now, it's very important from a sympathy angle. Now, as an attorney, you obviously won't rely on the law, but I like to add some sympathy. This man has been living there continuously for 29 years, never had a claim, gets out, goes to nursing home, rents out for a year, house burns down, the insurance company says, no, you didn't continuously occupy, sorry this happened, pick up the pieces. So here's Nationwide Mutual Fire position. You could probably already anticipate what they're saying. They denied because plaintiff had not resided in the residence premises for an extended period, even though extended period is not a policy, and not notified Nationwide that the property was rented to tenants. That's their position. All right, so here's the relevant policy language, and you could probably hear my 2-year-old son, that's Brooks. The relevant policy language is residence premises. Now, keep in mind, I've given the ones that were already shot down by the courts in Pennsylvania. Residence premises means the 1, 2, or 3, or 4 family dwelling, other structures and grounds located at the mailing address shown on the declarations unless otherwise indicated. Now, one thing you have to notice, there's certain language that's missing. I don't know if you can see it, but the where you reside language is not actually in there. Actually, I'm sorry. Give me 1 second. Sorry about that. My 2-year-old entered the room. My wife's getting him. He's being escorted out. So, all right. So one thing that supports Bill Wilson's argument, remember when he said that the language where you reside is actually an indicator of just the property and not so much a condition of continued occupancy? In this language, at least in this case, it seems to be replaced by at the mailing address, which seems to indicate that Bill is right. It's really just indicated really the property and not so much a condition for continued occupancy. Now, compare that language that's in the policy that was in that case to the 3 in which the residency requirement was upheld for the insurance carriers in the Third Circuit in Pennsylvania. First, Campbell v. State Farm. That was that really damaging case. The 1, 2, 3, or 4 family dwelling where the insured resides, I have it highlighted, and which is shown in the declaration. Bell v. Allstate. 1, 2, 3, or 4 family structure identified as the insured property on the policy declarations where you reside and which is principally used as a private residence. And Garreau v. State Auto. The 1 family dwelling where you reside and which is shown at the residence premises in the declaration. We'll go back to the language that's in my policy, in this case that I have in Western District, and you won't see any of the highlighted language in this provision. Again, where the insured resides, where you reside, which is principally used as a private residence, where you reside. Again, missing from this resident premises definition. So that's one argument I make to the court. Essentially, when I'm making this argument, I'm trying to let the court know, hey, listen, even though the Third Circuit has generally ruled against the residency, well, ruled for insurance companies in terms of requiring a continued occupancy, my argument is essentially this policy language is different. Different insurance policies have different languages, much like when you have the coverage day provision, like actual direct physical loss or risk of direct physical loss. It's not just the same provision, it changes between policies. So that's the first argument I have to make. But then as an attorney, I also have to have something up my sleeve. I need to have certain authority that also backs up what I'm arguing. And one thing that we have at Merlin is we have a nationwide database in terms of Westlaw, where I can look at any case anywhere in the country and also look at the briefs of any case in the country. So I checked the Third Circuit, nothing that really supports, but go outside the jurisdiction, and I find a case out of Georgia, Hill v. Nationwide Mutual Fire. Now, what's important about that heading is that the insurance company, Nationwide Mutual Fire, is the same defendant that's in my case. It's the same policy. And that's something I needed to make clear to the court is that this is the nationwide policy. Even though it's not a Third Circuit case, this is a judge ruling on nationwide policy. So in the facts of Hill, that case, the insured moves from home in June of 1992 and fire damaged the property in August of 1992. The resident premises definition in that case, now it's changed a little since that time. This is a 1994 case. The nationwide resident premises definition states a one or two family dwelling, other structures and grounds, or that part of any other building where you live, shown as the residence premises on the declarations. Now, in that nationwide case, that policy is actually stronger for any argument in terms of a condition for continued occupancy. However, in that case, the court did not read a residency requirement based on that language. And in this case, it is my job. I need to make it clear to the court that this is a nationwide policy. And in fact, as I'll show, and I have to make it very simplistic to a judge, I combine the nationwide resident premises dwelling definition in this case to the one that did not find a condition of continued occupancy in the Georgia case and show the court that there was actually stronger language for a condition of continued occupancy in that case, and it was shut down. It has the where you live language in that, it was still shut down. This, we don't even have that where you live language. I have to make that clear to the court, and I'm hoping I don't get a short-sighted judge in that, because I'll tell you right now, again, with the federal court timing, it still hasn't been ruled upon. Even when I presented this case presented this presentation back in October at the PPA&J meeting, it still wasn't ruled upon then. So it's been a few months. So again, federal courts are a little timely. I did want to get into another snippet in terms of also the personal property and how another provision could clearly conspicuously provide coverage for personal property, even if there is a condition of continued residency that is applied. In this policy, under coverage C, it states, we cover personal property owned or used by an insured at the resident premises. At your request, we will cover personal property owned by others. It must be on the part of the resident premises occupied by insured. This extension of coverage does not increase the limit of liability. The important part of that is the very first sentence, which I've highlighted. We cover personal property owned, ignore or used by and insured at the residence premises. Using the facts of the Pittsburgh case, remember, my client left a furnished property to the renters. There is no evidence that he actually gifted that property or gave it to the insureds. He left it there. It's still his property. It was technically property owned by the insured at the residence premises. So we took the deposition of the corporate representative, who is Mike Zerby of Nationwide, and I've actually quoted a few of his depositions in the blogs. He gives great testimony that I'm able to pull out of him. But essentially, I bring up the coverage C provision, and I ask him why wasn't the personal property, even if you want to believe it applies to dwelling, why wasn't it applied to the personal property based off this clear and conspicuous language under coverage C. And at first, his response is he points to the coverage A portion, which I have to remind him, you realize there's different coverages. There's coverage A, B, and C. I'm talking about the specific language in coverage C, and I read it over for him again. And so we get to, and I say, oh, question, but you agree there's not the same kind of language under coverage C, personal property. The coverage C language was different than the coverage A. He says, well, no, I don't agree with that. It says coverage C, we cover personal property owned or used by insured at the resident premises. And then I say, okay, question, you agree that there's the word or between owned or used. We're getting into the coverage C policy language that I had shown. And he states, well, that is, yeah, it's owned or used at the resident's premises. It's starting to get in his mind what I'm trying to get to him. I say, would you agree that Mr. Hay owned personal property that was damaged by this fire at the resident premises? Answer, he has to. He's starting to stutter. In order for coverage to apply, he has to reside there. And I asked, where does it say that? And he states, okay, I see what you're saying. Yeah, I'm looking at the dwelling piece versus the contest piece, but I see what you're saying, yes. Question. So based on your testimony, you agree that there's no residency limitation under coverage C, personal property, as you're reading it in this denial letter, correct? Answer, of course, counsel objects. And you know when counsel objects, you're getting somewhere. Answer, there's no specific reference to it, no. And there's two parts to the motion for summary judgment, one for coverage A, one for coverage B, coverage C. And at the very least, I quoted this deposition transcript in my argument. At the very least, worst case scenario, if I get a short-sighted judge who's only notices the Third Circuit opinions, doesn't realize that the only case that's been brought about in terms of the nationwide policy was the one I cited from Georgia. Even if they rule against me on the A, I should have the C. I'm fairly confident on that. And C, I believe that we had $80,000 on that. So final thoughts, as I kind of alluded to, it's still pending. The federal court, it takes a while, but it's very interesting to see how the judge is going to rule. I think if I have a very insightful judge, or his law clerk, whoever's reading the motions, I think if I made it clear to him that, listen, even though the Third Circuit and Pennsylvania is generally unfavorable to this, I think I did make it clear that there's different policies, there's different insurance companies, and there's different language. And the language in this nationwide policy has not been interpreted by the Third Circuit. Therefore, we have to look elsewhere. And I cited the Georgia case. And that Georgia case is the only case that was cited by either party in which a judge reviewed a nationwide policy language and ruled that there was no, in that language, that there was no continued occupancy requirement. And hopefully I hammered home to him that even that language was more favorable to the insurance company than the language we have in this case. So I'm anxious to see how it comes down. You never know when the federal court's going to come down. Could be in the next few months, but it'll be very interesting to see how the courts rule on that. Sudden and accidental, this is the second part, and this is a shorter part of the presentation. Is sudden and accidental defined in insurance policy? No. Sudden, not accidental, not sudden and accidental in the phrase. Typically not. In fact, I can't remember seeing it defined in the insurance policy. So what happens? You go to Merriam-Webster's definition. Sudden, under Merriam-Webster, happening or coming unexpectedly. Accidental, occurring unexpectedly or by chance, happening without intent or through carelessness, and often with unfortunate results. Accidental is typically very easy. Obviously, the opposite of accidental is purposeful. Insurance typically don't purposely cause damage. So usually accidental is they usually agree to that. The usual argument lies in terms of whether or not something that happened was sudden. And again, it's not defined in the policy, so you have to look elsewhere. Just a bit of a background in terms of New Jersey policy interpretation, because obviously judge ruling in this, he has to take on a few precedent in terms of how to interpret policies with insurance policies. So one, ambiguity is for the court to decide, not the jury. Two, when an insurance policies, I'm sure you've heard this before, when an insurance policies language fairly supports two meanings, one that favors the insurer and the other that favors the insured, then the policy should be construed to sustain coverage. Essentially, tie goes to the entity that did not draft the document. Insurance policies are contracts of adhesion. The policyholder cannot change the terms of the agreement. It's a take it or leave it agreement. Therefore, the courts know that. They understand the insurance policy is drafted by the insurance company. If they can't draft a clear policy, if they can't make their provisions clear, then the court finds it's ambiguous, then it should find in favor of the policyholder in terms of that ambiguity. The next canon, essentially, is the fact that a term is undefined does not mean that the policy is ambiguous. So in the case that I have, just because I point out that sudden and accidental is not defined in the policy, that does not mean I automatically win. It just means the courts have to go somewhere else to make an interpretation. If you hear the phrase sometimes, it's plain and ordinary meaning, even though I'll say that that's essentially vague. The judges will essentially just go to dictionary terms. That's usually what they do when something's not defined in the policy, and they'll make their own interpretation. So they'll look at the term and they'll make their own interpretation. The last canon, in instances where the policy language is ambiguous, the reasonable expectations of the insured will be applied, even if a detailed analysis of the policy provision would undermine such expectations. So a reasonable interpretation of the insured does play a little bit of a factor. And it's important when I prep clients for deposition testimony that eventually I somehow they get in their reasonable expectations. If not, I'll obviously do it in direct in an arbitration, or if it got there in trial. So we get into the case study. This case revolves around a hidden failed wax ring. There's a photo. The wax ring, obviously this is a good wax ring. There's no damage to it. Two things though. The wax ring, it's hidden. Obviously the toilet's knocked over, but it's hidden. And in this case also too, this failed. And we'll get into the facts of the case, but if it's going to fail, the water's going to seep below and it's going to be hidden. So we'll get into the case facts here. What happened was the insureds, this was happening, the wax ring failed and water's leaking down into essentially their ceiling, down the walls and into their electrical. Lights in the house flickered. And it's undisputed in this case that there were no other warning signs until the lights in the house flickered. These insureds are great. They did everything they were supposed to do once they had noticed something was wrong with their property. They immediately investigated. They opened the living room wall that night and found electrical wiring behind the wall was burned. Still that night, they also immediately shut off the main valve and they called the electrician that same night. The electrician comes out. They eventually find the failed wax ring under the toilet of their second floor bathroom had leaked water down to the first floor. It's also undisputed that the wax ring was not visible. So again, there was no notice at all until the lights flickered that there was an issue in the property. Also, what's not disputed is that this was happening for a long time. Both sides got engineers. Our engineer even agreed. This wasn't something that just started happening. This has been happening for months. So those are the undisputed facts in this case that we're going into it. And again, we had to get into a policy interpretation. So the carrier, they give one of those exclusions where they're throwing everything against the wall. They're relying on the wear and tear. They're relying on rust corrosion. They're relying upon the seepage. They're relying upon defective design and even mold and fungus. The ones we're really going to focus on for this case were the wear and tear and rust corrosion and the seepage exclusion. Now, this was an Allstate New Jersey case. So Allstate New Jersey policy, the number 15 exclusion, the one that contains the wear and tear and the rust corrosion, their subsections A and D. It's up on the screen, but it also has that ensuing loss provision. And it was very important in terms of this case. The ensuing loss provision states, if any of A through G,
please check
which
in now,
contains the wear and tear and rust corrosion, cause the sudden and accidental escape of water or steam from a plumbing, heating, or air conditioning system, household appliance, certainly a toilet could fall under a plumbing system, household appliance, or fire protective sprinkler system within your dwelling, we cover the direct physical damage caused by the water or steam. What's important is there's no temporal element. There's nothing in that ensuing loss provision that limits the duration of the water leakage from the wear and tear appliance or the wear and tear plumbing system. There's no limitation. Much like I understand the seepage exclusion does. They have the 14 days or weeks, months, years. This doesn't. This doesn't have a limitation on duration. If you just read this ensuing loss provision on its own in this only exclusion, this covers for sudden and accidental escape of water with no limited duration. What this case came down to is whether or not the leaking of the water from the worn, torn, failed wax ring was a sudden event. That's what it came down to. During the deposition, I took the corporate rep deposition. He admitted that this was an accidental loss, but was it sudden? That's the dispute. They felt that this was not a sudden loss. So in cross motion, our position was that the escape of the water from the failed wax ring is sudden and accidental as defined by Merriam-Webster's, that it happened or came unexpectedly. The insurers certainly didn't expect this. So it has to be sudden based off the deposition. They weren't expecting it. It's sudden. It's not defined in the policy. We look to Merriam-Webster's. It fits the definition. We rely on the ensuing loss provision, that it covers sudden and accidental loss without concern for duration for something that's wear and tear or failed, like that wax ring. The insurance carrier, again, they filed a cross motion. They filed their own motion for summary judgment, looking to win on their exclusions. Their position, and in fact, at first they misconstrued our argument. They were under the anticipation that we were arguing that because they found the damage suddenly, that we were making an argument that was sudden. That wasn't our argument. Our argument was that the water escaping from the wax ring was sudden, not just the discovery. They also argued that the leak was long-term, and they pointed to the plain language of the policy, but it wasn't clear. It was a very vague argument. And what was most damning to them is they didn't cite any kind of New Jersey case law at all. The only case they cited was a lower level federal court case in Minnesota. So if you know pleadings, obviously you have the initial pleading, you have the opposition, but then I had a chance to reply to their opposition. And during that reply brief, I just showed that their sole authority was that New Jersey their sole authority on how New Jersey interpreted the term sudden in the insurance context is a non-binding, out-of-state, lowest level federal court decision from Minnesota. That's it. That's what they came to the table with. That's what they could find. And what was also important that is, even though the case that they cited, if it was applicable, would not find coverage because sudden. What I found in terms of looking at Minnesota case law is that Minnesota had already determined that sudden does not mean unexpected. They've ruled differently. There's nothing in New Jersey case law where they've made that determination. So there was a distinction that had to be made there. Otherwise, they had nothing. And I also, again, hammered home that the duration of the event is not relevant to whether the event was sudden. And then the court's order, we did get an order on this, and the court did grant motion for summary judgment in our favor. And what's also great about it, it wasn't just an order that said, okay, your motion's granted. It was a written opinion. So the ramifications of this is that if say that any other policyholder's attorney has an insured who had a loss with, say, Allstate, New Jersey, or really, this applies over a lot of policies because sudden and accidental is not defined. It all depends upon the language of the ensuing loss provision. But if you have a client with a similar language and they have a loss, hidden damage, and there was really no way for them to tell that there was any kind, even if the damage has been going on for months, if they had no reason to tell that there was any kind of issue, then you can rely on this based off the wording of the ensuing loss provision because, one, it pays for sudden and accidental loss after the wear and tear, and two, there's no limitation on the duration. So if you want a copy of the order, I'll post my email again, because again, now if insurance companies, if it does get into these motion stages, then even if it's a lower trial court decision, even if it's in another county, and insured's attorney can now attach this to their motion and say, hey, listen, this has already been ruled upon in this similar issue. The court has already found, or another court in Burlington County has already reviewed this and made a determination in favor of the insured. In this court order, it states Sudden is ambiguous. So he made a determination that Sudden is ambiguous and undefined in the policy. Insureds were left with their own reasonable interpretation of the term Sudden. Ambiguities are to be construed against the insurer and in favor of coverage for the insured. More than one reasonable interpretation of the ensuing loss provision. Sudden, in reference to the ensuing loss provision, refers to an escape of water that was unexpected or unforeseen without a temporal requirement of immediacy. That's huge. Water damage to home was both unexpected and unforeseen, irrespective of how long it took to manifest itself, and coverage was afforded. And again, yeah, if you'd like a copy of the order, you can email me, dballard@merlinlawgroup.com. I think it's a very good order for policyholders in New Jersey. In terms of the Western District of Pennsylvania case, obviously that's federal court, that's a Third Circuit case. We'll see how that goes down. Potentially maybe in a blog that I write at some point, but again, federal court, it takes a while. Other than that, feel free again, if you want to check out our blog, you can subscribe, reach out to me. We'll get you set up. I see Mark has a question.
I do, Dan. If you entertain this, look, anybody can be wrong, including judges. And so just because they rule on something at one point, isn't it possible to change, to create new precedent, despite the fact that something's been ruled on, right?
Correct, absolutely. So say if this same situation happens in Morris County, the judge doesn't have to accept this order in Morris County. A judge can make his own decision. Again, it's a lower level trial case. In Burlington County, so if you have another case like this in Burlington County, it's obviously going to have more effect, and the judge is most likely going to follow in favor. But in other counties in New Jersey, they don't have to follow it. However, it is persuasive. It could help, is essentially what I'm saying.
One other thing, if I could. I'm annoyed with the rulings with regard to the Sixth Circuit Court of Appeals out here, in that they're allowing the definition of a commonly used word, labor, to include depreciation of materials. And I think that should be a revision to how we settle claims, and not redefining the language like a Merriman, like Webster. You can't redefine language because we basically argue what the language is. So I think that's a little bit backwards, and I think that needs to be challenged, and I think that we need to continue to fight labor depreciation.
Absolutely.
Even as it appears as a definition. I think that's a very wrong ruling.
And there's also, I'm sorry, Mark, go ahead.
No. I mean, I don't like the way these judges rule. They said that this word means something different. It's okay to say that you can depreciate, you can apply the depreciation factor to labor, to overhead and profit, and to tax, but not to redefine the word itself. I think that that's wrong.
I agree. And some judges just flat out get it wrong too. They do.
Guys, we're going to wrap it up. We're going to wrap it up here. Dan, thank you so much. Dan went through a lot to make this work today. We had 3